Welcome, everyone. I'm Elizabeth Hobson. I'm the director of the Dobbs Ferry Public Library, and I'm delighted to introduce our speaker tonight. Anthony Nigro is a estate lawyer here in Dobbs Ferry, and he is actually very familiar to us because his wife used to be on our board of directors, and we're just delighted to introduce him and have his presentation tonight, which happened thanks to Victoria Jones, our illustrious, now emeritus president of our Friends of the Dobbs Ferry Public Library. And she's a professional fundraiser herself and does a lot of dealing with estates. So I'm sure between Anthony and Victoria, we're going to have a really great discussion tonight. If you have questions, there's a chat bar. You can access it by the bottom of your screen. If you roll your mouse over the bottom, you can bring up the chat and you can write in questions there. We're going to save the questions till the end, and then we can ask them all at once from Anthony. So without further ado, welcome, Anthony.
So Vicki, can you say a couple words?
I just want to say a few words to start off the program. I'm happy to have Anthony here this evening. You might say what motivated this estate planning primer. I have to thank one of our friends, Walter Adams, who was one of Mary's neighbor, who sent an email to the Friends of the Library at the beginning of May saying, hey, I know you're friends with Mary. She's been taken to the hospital. Do you know her next of kin? And unfortunately, I did not know Mary's next of kin, but I said, let's call Joanne Fabric where she works and see if they have a next of kin. They did not. So knowing that as long as Mary was breathing when they took her into the emergency room, there would be a name. So Mary had given the name of her dog walker because her dogs were one of the most important things in Mary's life. So I just said to the woman, please tell Mary that Vicki Jones knows she's in the hospital. If she needs anything, please let me know. And they were transferring her from Dobbs Ferry Hospital to Westchester Community Hospital. And I called her there and I said, okay, Mary, if there's anything you need, you let me know. She said, fine. She goes, you're my healthcare proxy. And I was like, Mary, I'm your healthcare proxy. Well, we have to talk about some things real quick. And fortunate for me, I work for Weill Cornell Medicine, so I'm very familiar with what kind of questions were in a healthcare proxy. Pulled one up on the internet and we went over several of the questions to help guide me in helping Mary with what her wishes would be. So at that time, I had said to Mary, okay, Mary, who has your power of attorney? Who's your next of kin? And we went through all of these type of questions and had a lot of very intimate conversations with a friend I've known for 30 years, but didn't know as well as maybe I should have known. So anyhow, Mary and I caught up on a lot of things and her wishes and desires. And she was in Westchester Community Hospital for 1 week, transferred to Cabrini Nursing Home. And at that time I said to Mary, do you have a will? And she's like, no, I don't have a will. I said, well, if you don't have a will, this is what's going to happen to your money. She said, get me an attorney quick. Now this was in COVID, and fortunate for me in my training as a gift officer, I learned that there was a way that attorneys could do a will in COVID over the internet using an iPad and do conversations over the telephone. And I reached out to Anthony because I knew Anthony had moved his practice from Mount Kisco to Dobbs Ferry. And he said, don't worry, Vicki, I'll help you work through this process. I'll help you help Mary. So that is why we're here today, is because Mary, I helped Mary, and Mary in many ways is helping me because I've been married to Jim Bergen down, square number 4. For approximately 10 years. And I myself have not redone my will since I've been remarried. So Mary is helping me do what I need to do. And that's because I helped her do what she needed to do. So it's full circle. And I just hope that we're able to help you in understanding how very important having an estate plan is. Okay, Anthony, take it away.
Okay, thanks for having me tonight, guys. I'm not going to try to talk too much and get through the big points. We're going to start large and we're going to narrow in at the end. And I'm happy to answer any of your questions. Any super specific questions we can probably talk about in person, but I'm happy to talk generally. I'm not actually allowed to give attorney advice to people who are not my clients, but we'll find a way. Okay, so this is my primer, and the first question that comes up is what actually is estate planning, right? And I believe that it's the orderly transition of your estate, which is your assets, to your loved ones. And on top of doing the financial planning, we do a bit of emotional planning as well, because it's equally important. When you do eventually pass, which we all do, right? There is an emotional component revolving around that time and the time after you pass. And the better prepared you are, the better your family's going to handle it, and the easier it's going to be for your loved ones. And that's a big part of this whole thing. I like to think of everything I do as insurance policies, right? A will or a trust as an insurance policy that your stuff goes to who it should go to. A living will is an insurance policy on what happens in case you can't make medical decisions and your proxy needs to make those decisions for you. And the power of attorney as an insurance policy for your finances while you're alive if you become incapacitated, that someone can step into your shoes and actually do what needs to be done. So that's how I like to envision everything I talk about today. And I'm probably talked about all of these questions already quickly, but this is the first part, right? This is who will get it, where will it go, and who do you want to give it to, right? If you were younger, I don't know the average age of the participant tonight, but many people come to me in Dobbs Ferry because they have young families and minor children. And the biggest issue there is usually, if we both die, who will be the guardians of our children? Tonight, that might not be a super relevant issue. Okay, so what is your estate, right? What is included in your estate? Anything that you own, whether it be cash, savings accounts, checking accounts, stocks, bonds, real property, or co-ops, individual retirement accounts and 401ks, and annuities and life insurance policy. All of these usually, and also I would throw onto there your personal property, the stuff in your house. All of this stuff encompasses your estate, right? And when we plan, we need to know how your accounts are held. And I'm talking every account, how it's held. Is there a joint beneficiary on there? And do you have beneficiaries designated on these accounts? And if you do, does it line up with the plan that we are customizing for you? Because it needs to fit into the puzzle. So the first thing I always have my clients do is actually get a list of all their assets and a secondary list of how those assets are actually held. Oh, personal property was on there. Good for me. In New York, if someone dies without a will, right, it's usually not in your best interest. Let me get through here quickly. Okay, so this is EPTL 4.1-1. Very familiar with it, and it's not really what most people want. What it says is that if you die without a will, the first $50,000 in your estate goes to your spouse. The rest of your estate is split equally between your spouse and your children. And this is with no will, right? So this is not a great idea if you have a spouse who needs that money to survive the rest of their life. If you forget to plan, then if you're, depending on your relationship with your children, this could work out not in not a great way, right? Because the children are entitled to 50% of your estate. In reality, most people hold things jointly and it does pass their spouse automatically, but everyone's situation is different, right? But just keep that in mind. It's We never really want to rely on intestacy for estate planning. Not a great idea. This is my website. I think I made this slide a long time ago, but if you're more of a reader, feel free to visit my website and you can read through my blogs. And every once in a while, I'll try to write a blog on something I believe is pertinent for people's lives and not so boring. Okay, so what if you have a will, right? What happens then? So when you have a will, we draft it, we talk about, or you and your attorney, whoever your attorney is, you talk about what your wants are, who's going to be the executor, where your stuff is going, and eventually, you know, that will is needed when you do pass, right? What happens when you die? So someone must actually physically take that original will and bring it to the surrogates court. They attached a petition, for the executor will attach a petition to be appointed as executor. And all of this information is public. For most people, that's not a problem, but some people are more private and they don't want their information out there. And then we would talk about other approaches, such as a trust, right? When you do go into probate with a will, there is a bit of court oversight, right? They want you to, they're there to make sure that you're acting in your fiduciary capacity. If you are the executor, which Vicki knows well of what that fiduciary capacity entails. But the court is looking over your shoulder this entire time. And they do have the power, they never do, sua sponte, to make you account or do something like this. Usually it comes from the beneficiaries, right? It's usually more like the beneficiaries want their money and they look to you and they start calling your attorney and they start calling you and they start saying, hey, where's my money? And that's where some of the issues come in probate, right? And there's many other issues that can happen. But that's basically, this is what happens with a will. You draft, you bring it to probate, it gets administered through the court system. And mostly you're doing the work, but the court is involved in some capacity, more of an oversight. So this is talking about another thing. What if I get sick or disabled in some way, right? This is where we start to talk about healthcare proxies and living wills. These are two separate documents, right? A living will states what you want to happen regarding your end of life care. So if you're unable to make decisions for yourself, what would happen is your proxy, your agent under your healthcare proxy, will lean on the living will. And it should encompass most of the decision-making that needs to take place, right? So A, their job becomes a lot easier, and B, it prevents litigation, right? Because we've all read the New York Times and we've read these articles where families start to sue each other just in case someone falls into a coma and whether or not they're gonna pull the plug. We've all read those. And these two documents are the insurance policy against that litigation, right? Because we have two valid, binding legal documents that state exactly what your wishes are, and then further through the healthcare proxy, that will designate who's in charge of making those healthcare decisions, right? And this is a component of the estate planning. Okay, so this is a question for a younger family who has younger children and does not know if they are ready to come into some money, right? When we have children who are inheriting, if they're under 18, the Uniform Transfer to Minor Acts comes into play. What that is all of the money goes into an account. It sits there until they turn 21. And then upon their 21st birthday, they get all of the money all at once, right? So if you do a very basic will and that basic will does not have a minor trust set up in it, then if a minor does inherit under your will, they basically get that lump sum amount when they're 21. And that's okay for certain kids and very much not okay for other children, right? So every client knows their children best, and it's a matter of personal preference of how heavily you're going to plan and how heavily you're going to restrict those assets from the grave. And it doesn't have to be your own child. It could be a nephew or niece or any minor child. So when planning for your estate or any estate, one of the biggest issues I always have to think about is there tax liabilities, right? There's two main tax liabilities in New York. We've got the New York estate tax and we got the federal estate tax. The one thing Trump did do is raise the federal estate tax to over $10 million. So you have to have a lot of money to pay federal estate taxes. I think I've got a slide here on this. Okay, so this is an old slide. The federal estate tax is no longer 5.43 million. It's actually it's over 10 million. So although many people in Dobbs Ferry are very wealthy, $10 million is quite a bit of money. And I've yet to have a client, at least in Dobbs, to go over this threshold. It does happen, but it's just something to keep in mind that if you do have $10 million, you definitely want to talk to an estate attorney because you're going to pay a ton of taxes unless you start planning immediately.
Unless they talk to me.
Yeah, Vicky, they can definitely talk to you and start giving it away. That's for sure. So here's a more current slide that I actually updated. New York estate tax is $5.8 million this year, right? So still quite a good amount of money, but feasible, right? Some people do have this amount of money, right? And you'd be surprised. A lot of people do. This amount is not just your cash. It's your cash, it's your stocks, it's your real property, it's your personal property, and it's also, and here's where people get go over very quickly, it also includes your life insurance. So if you have a large amount of life insurance, your estate can easily be pushed over this $5.8 million mark. Again, it just depends. New York does not have portability, which means that it's a really nifty tool and a very basic tool, actually, where you're allowed to give your spouse your unused federal gift and estate tax exemption. And it saves you a lot of money, but New York doesn't have it. They also have a fiscal cliff, which means if you go over this 5.8 by more than 5%, you're gonna owe taxes on your entire amount of money, the whole thing, not just what you go over the 5.8 for. So again, it might not affect you, just something to keep in mind. Okay, here's my basic package, and any estate attorney is going to say, okay, this is what I need you to do at the very minimum, right? I want you to do a last will and testament so we have an orderly transfer of your assets, the power of attorney in case you can't make financial decisions for yourself, the living will, the healthcare proxy, which we spoke about, and then you want to update your beneficiary designations on all of your accounts to make sure they're valid, and start talking to your insurance professional about life insurance or even potentially long-term care insurance, which used to be a much easier tool, but it got very expensive in the past 3 years. And I think there's only 2 underwriters issuing these policies now. Long-term care insurance, if you don't know, is a policy that if you need full or part-time care, health care, right? So say in-home care at your house or even nursing home care, the long-term care will pick it up to a certain amount of money or up to a certain amount of years. But the downside is it's very expensive, but definitely worth the conversation with your life insurance professional, definitely. Okay, here's a little more complex part of estate planning, and it's very common these days. So people work their entire life. Most people that I work with will have a house. They'll have a few $100,000 of cash, stock, bonds, and they will have maybe an IRA, right? And what the children and sometimes the client themselves are afraid of is if their mom or dad ever has that terrible health event where they need nursing home care full-time and may or may not qualify for Medicaid, right? And this is where it gets expensive, and I mean very expensive, right? So in Westchester alone, it's roughly $400 a day for nursing home care. And at the end of the year, you're talking $150,000 a year. So if people, some clients come to me proactively because there is a 5-year look back period on this stuff. And what we're able to do as estate planners sometimes is if you line up correctly within the parameters and your income levels are of a certain level, we can protect certain assets from a potential Medicaid lien, right? And this leads into the Medicaid planning. So
Yeah.
what is Medicaid, number one? And how does it work in New York, right? So Medicaid is a means-tested system in New York where if you have a certain amount of income or a certain amount of assets, you will not qualify and you will have to pay out of pocket for one of these events. But if you properly plan and retitle your assets, and it's really a shell game, right? I'm not gonna act like it's anything that sophisticated. What we do is we take your assets, and if you're comfortable giving up control of these assets, and we can put it into a Medicaid trust or an income-only trust, where if you don't need the principal anymore, if you're comfortable enough on your income or other monies, we can safeguard whatever we put into this irrevocable trust from a potential Medicaid lien one day in the future. And there are certain restrictions that apply here, right? One of the restrictions is that there's a 5-year look-back period for nursing home care. As of this October 1st, the New York State Legislature also just passed a law that there's a 3-year look-back period for in-home care. Up until September, our job as estate planners was rather easy. There was no look-back period, which was great. But now you even have to plan for that, which makes it even harder. What happens if you do qualify for Medicaid one day? Medicaid will look to get whatever monies that they gave you back when you die. So it's not free money, right? So if you qualify for Medicaid and say you end up in a nursing home for 2 or 3 years, they're gonna try, if you have an estate, and that's a big if, but if you do, they're gonna try to attack your estate, lien it, and get every dollar back. And they used to make deals and they used to be really nice, and they're not nice anymore. And they want every dollar. So it's really imperative that you at least contemplate these thoughts and think about estate planning if you have some assets to protect and a potential nursing home event is a possibility, right? And that's crazy. I know it's crazy to say. Like, how do I know that I'm going to go into a nursing home? No one does, right? But things to think about. If you have dementia that runs in your family, right? If you have Alzheimer's that runs in your family. If you had a grandparent or parent who ended up in a nursing home for an extended period of time, then your risks go up for this potential event. And then I would seriously contemplate talking to an estate planning attorney and doing some, and this is obviously more advanced planning. And when estate attorneys say that, that means more expensive. So be aware of that. Let's see. Everyone's situation is different, right? So I can't give a blanket approach to estate planning. Some people are married a second time. Some people are married a third time. Some people are single. Some people are single with children. Some people want their money to go to their kids. Some people want it to go to charity, right? So everybody's different. And this is a very individualized and personal conversation. So you have to speak one-on-one to an attorney at some point, right? There are lots lots of avenues to go down, right? And this is not a comprehensive list, but this is like a taste of complex estate planning, right? You can get into some really funky stuff depending on your needs. And it's up to your situation and what it calls for. I'm not going to go into all of these. It would be a total waste of time, but I am happy to answer any questions. I flew through that. I apologize if I went too fast, but let's talk. Tell me about any questions you have, and I'm happy to answer them. Yeah. Vicky, do you want to talk about how to make a, go ahead.
Well, I was going to talk about some of the donors that I've had that have created trusts that, you know, they want to be able to take care of perhaps either a child with special needs or a son that has addictive personality.
Yeah.
Or they have a son who's been divorced twice already and they want to protect the assets so that he won't completely spend down his inheritance. So I had one donor actually create a $5 million trust that was a charitable trust that the son was only, at the time his mother passed away, 57 years old. And the reason she created a trust is even though the market will go up and down, in the long term, the money will grow, not only grow to take care of her son, but also grow to make a gift to Weill Cornell. So that was a really great gift that she did. So trusts are good for, I know they talk about it, you know, some people call it, you know, the hand from the grave because you want to protect, you know, the assets that you worked for all your life, but it's to protect your children when they're not capable of making good decisions.
Yeah, so I mean, I really didn't touch on too much trust work here because trust work is very individualized. But a trust is a beautiful tool when you have some issues going on, and we can really manipulate the language in any fashion that you see that would benefit your beneficiaries, whether that means restricting those assets or really restricting some, giving to some. We can really do whatever you want within a trust. It's a beautiful, beautiful tool. Yeah.
I have a question.
Go ahead.
Are you an elder care attorney, or can you talk about what the differences are between estate and trust attorney versus an elder care attorney?
Yeah, so I get that question a lot. I'm happy to speak on it. So
Great.
I do a good deal of probate, estate litigation, and estate planning, but I would not call myself an elder law attorney for one reason, right? I do not do Medicaid applications, and I never want to see one ever, right? So many elder law attorneys are going to be able to plan for you, and they're going to be able to, once you need more care, they're going to be able to do that Medicaid application for you. So I am totally competent in planning as long as we have it. As long as we're planning in advance, I would say I'm fine stepping into that role. But if there's an emergency situation or a Medicaid application needed, say someone did not plan and they're going to a nursing home, then I do refer those cases to what I would call elder law attorneys. Yeah.
But don't the nursing homes themselves often do the Medicaid application?
So yeah, the nursing homes often do Medicaid applications, and it's usually in the nursing home's best interest to do them because they want to get paid their money, right? Because you're not
Right.
paying. So many times that when they do it, and again, it depends on your assets and how much money the person going in has, but it may or may not be in that person's best interest to get an attorney. I will be able
Okay.
to say this. If someone has no money or very little money and they don't want to pay an attorney to do a Medicaid application and the nursing home is willing to do it, that's great. Let the nursing home do it, right? Because you don't have anything to lose. But when you have assets to potentially lose, I highly recommend speaking with an elder law attorney.
Okay, thank you.
Yeah. Anybody else have any questions?
Somebody's just coming into the room now.
Okay, take your time.
I had a
I have a-
question. This is
Oh, no, go on.
This is Jihei. I had a question. I was just wondering, thank you for this presentation. I was wondering, Anthony, as far as the election and how that might potentially change some of your work, and is there any thinking around that?
Okay, that's an interesting question. Yeah, so if Biden wins, right, you're probably, my guess would be that you may see a drop in the federal estate tax exemption, and it may come down to levels that it was previously, right? So what New York did was New York graduated their estate tax limitations to 5.8, which used to be the federal limitation, right? But Trump raised it for the very wealthy in the country. I'd imagine that if Biden gets elected, it's going to come back down to that 5 to 6 range. And then it will affect considerably more people, remembering that life insurance is included in that calculation. Yeah.
Okay, thank you.
This is Amy again. I have a quick question about the life insurance you mentioned.
Yeah, go ahead.
So if life insurance is, if you list a beneficiary for the life insurance, I always thought that was outside the estate.
It is. So it's interesting, right? It does pass specifically to that beneficiary, but it's calculated within your estate tax calculation. Yeah.
That's really interesting.
Yeah. So,
Okay.
you know, lawyers, right?
Yeah.
But yeah, that's the answer on that one. You know,
Okay.
it boggled me at first too. I was like, why? Doesn't make sense. But it's because the government wants their money, right? That's why.
Of course they do. Yeah.
Yeah.
On that note, I think we might talk a little bit about the Secure Act that passed at the end of December last year, where inherited IRAs now, if they're inherited by somebody other than a spouse, has to be spent down or received in distributions in a period of over 10 years.
Yeah, so there's not that much more to it there, Vicki. Like, what happened there was, I think about 4 years ago, the Supreme Court made a ruling where that inherited IRAs were no longer protected assets when it came to Medicaid liens. And it kind of it then led to the Secure Act, right? Which basically means you have to spend the money pretty quickly. And that could happen to a lot of people. A lot of regular people can be touched by this.
Yeah, I mean, it's like if their parents had saved money over a period of time, like say, you know, I know a lot of our faculty members at Weill Cornell have worked in their position for a long time and have accumulated a very nice size IRA.
Yeah. Yes.
And
correct.
if they have 1 or 2 children and have to accept $1 million over a period of 10 years, and they're actively working, that's like a huge impact to their tax rate.
The only positive that came from it, I would say, is that it did raise the required minimum distributions to 72 from 70.5. So if you're in a position where you don't necessarily need your IRA money, if you're fortunate enough, then you can hold off on it for another 1.5 years, allowing your children to potentially inherit more money, you know? Because a lot of times,
or they could give me $100,000 and their wife could give me $100,000.
yes.
And then they would have 2 professorships in either person's name. And then they would have less taxes for their children to pay.
Yes.
And they would live on forever. That's what I love about my job.
Is that applied to both the traditional IRA and the Roth, or just the traditional?
you know,
I'm not certain about that, about Roth.
I don't know about the Roth. Yeah, I couldn't answer that question right away.
I could ask us, I can ask a CPA, maybe they can give us an
Yeah, I'm sure
answer.
they would know.
Yeah, but I mean, it's something that this is all why, and this is all why it's very important for attorneys and financial planners to show everybody the cards on the table, because this is one way of, making a gift and reducing the taxes and protecting their family and teaching their children about philanthropy. I have a donor who I work very closely with her two nieces, who are the only surviving members of the family now. And their aunt has like millions and millions of dollars. I mean, like, they want to give me $5 million right now to create a chair at the medical college, but they can't because she has diminished capacity, and the former attorney has brought in a legal guardian. So, it's good to talk about your philanthropy and your philanthropic goals with your children, even from a small age. I think that if you have significant assets, people that usually do care about their library or their church or their alma mater, and there's smart ways to give. And that's why working with an attorney and working with somebody like me, a planned giving person, we're able to have a dialogue about what's your goal.
Yeah. And I think you're hitting on a super important point there, Vicki, and that's capturing whatever motivation you might have and acting upon it in a plan, right? So very often, I can't tell you, I have, maybe 8 to 9 files on my floor with drafted wills ready to be signed, and they're never going to be signed because people have lost their motivation and they won't answer emails anymore, and this has not become a priority for them anymore. So the only advice I like to give when it comes to this stuff is try your best just to get something done, right? Something is much better than nothing, right? And then maybe when you have something, you can start really thinking about it, talking with your attorney, and really thinking about everything you need to think about, and you can get to that perfect plan. But something is always better than nothing in these circumstances. Yeah.
Anthony, most people should realize that anytime there's a life-changing event, like say somebody got married 10 years ago, they might want to redo their will.
Yeah.
Or if
do a revocable trust there, probably. Yeah.
Yeah. Or if somebody if they change jobs, they no longer have that large amount of life insurance that they were going to give to their children, they might want to look and relook at their investments, their IRAs, and think about, how can we structure our estate plan so it can take care of our children and take care of our spouses and achieve our goals. It's like different life-changing events creates a different need in your estate plan.
Yeah, so that's actually the last sentence I say to all of my clients is, if you have a life-changing event, please call me back, right? And I define life-changing event as a very great thing happening or probably a very bad thing happening. Because in those events, we probably want to relook at everything you've done to make sure that A, everyone's still alive, and B, these are still your intentions. Yeah, great point, Vicki.
Another thing too, a lot of people might not realize is that it's important not only to have income beneficiaries signed up on your IRAs or your bank accounts, to have a listed beneficiary, but also have a surviving one in case something should happen. Like, let's say my husband was my beneficiary of my IRA. Well, if he passed away and the money was put into my estate, then it would be taxed in a different way. So, you should have like a successor beneficiary, right?
So in most circumstances, that's good advice. Unless you're doing a little bit of advanced planning where maybe some of those assets are flowing into the estate on purpose, and then you might not want a beneficiary there for very concrete reasons. For example, if you have minor children, you might not want to put the minor children as beneficiaries on your life insurance because it would create that UPMA account, right? But instead, we might want it to flow into the estate where we could set up a minor trust and we can get that money to them when they need it through a discretionary trust. But we could also restrict their access to that money so that they don't overspend that money, right? So just, again, it depends on the issue.
Yeah.
Yeah.
That's why talking to you is so important.
Well, it's not that important, but okay.
Talk to Jim Bergen. I think he thinks it's important.
Well, I've been waiting for you to do something, honey. It's your house and your kids.
You really want her to leave them to you?
No, I'm leaving the kids to you, Diane.
That's what I'm afraid of.
Yeah.
Is anybody else thinking of any questions that they might like to raise?
Oh, I came in late. I just want to make sure, is this being recorded and will be posted on the library website?
Yes.
Okay, thank you.
Do you mind, this is G. Hagan, would you mind going over the UTMA again? I know you had mentioned it a little bit.
So an UPMA
earlier.
account is a very simple account that is statutory. If a minor inherits money, then, and there's no minor trust within the will or trust, then that money would go to the minor and a guardian holds that money. And when they either turn 18 or 21, depending on the account, it's usually 21, then that minor gets the full amount of whatever the assets are in there with no restrictions.
Okay, so it's either through a trust or a will?
It can happen through a trust, but it's more common in a will situation where a minor may inherit and there wasn't any subsequent planning within the will for minors inheriting. So they do get their money, it just sits in an UTMA account until they reach the age of maturity.
Okay, all right, thank you.
Yeah,
I have a question. This is Scarlett. Can you hear me well?
yeah, I got you.
Yeah. Regarding the trust, the kids trust, the trust in, do I need to set up a living trust right now, or I can just put that trust in my will? Because
Yeah.
I have life insurance for my kids. I'm sorry, I don't know whether you have gone over this because I came in late. I have life insurance for my kids and they are the beneficiary. So of course, if I die, the money is not going to go to the kids directly because insurance will say they're minor. So the insurance told me you need to set up a trust. But I assume, the trust I can just put in the will. I don't have to set it up right now as a living trust. Is that right? No need, right?
That's correct, and I actually recommend that, right? It's much easier to not have a third entity in your life when you're a younger age. So you do a will, we place the trust within the will, and then upon your death, that will becomes effective. And as long as the beneficiaries are titled correctly, that life insurance money would pour into the minor trust in the will. Yeah.
But question, so you're saying, let me understand, I do not need to set up a whatever LLC or something right now in Delaware or whatever, New York, a trust right now.
Yes.
Upon my death, that trust will be automatically enacted by who? By my executor, is that correct? In my will.
So if you put the minor trust within your will, which I would recommend, then your executor would fund that trust with the life insurance monies, and the money would be there per the description of the trust for your children. Yes.
Okay, got it. So in my will right now, I can also say whatever, putting aside the life insurance, just like my $500,000 will go to the trust. I can say that in my will, even though the trust does not exist at this moment.
Yes, it could be a contingent trust upon your death.
Got it. And then, so basically you are doing the establishment of the trust in your will. And in the trust, in the will, you would say, I put all my money in this trust and the beneficiary of this trust is my kids. You can directly say it in your will right now.
Yes.
Got it. So you do not recommend people to set up a living trust. Suggest.
I can't recommend or not recommend anything in general. Everyone's situation is specific, right? But it's very possible to do exactly what you just said.
Okay. Because if you set up a living trust, there's expense, right? So it's better to do it do the set up a trust in the will. It's cheaper, right? Probably.
Well, it would be cheaper, I can say that, yes. Whether
Okay.
it's recommended or not would depend on your other assets.
Yep.
She may not have heard you earlier when you said that if you had a living trust, assets would be protected against Medicaid. Is that correct?
No, so that's not correct. Irrevocable income-only trust or a Medicaid trust will protect against a Medicaid lien after 5 years. A living trust is another word for a revocable trust. And revocable trusts, the only thing they do is avoid probate. They don't do anything else except avoid probate. Yeah, they do not plan for Medicaid.
So if I set up the trust in my will, it will go to probate. That the will and the trust will go to probate first.
That's correct, yes.
What is the value of avoiding probate? I've wondered this before.
So just quickly again, there is some privacy concerns, right? There is some expense that goes along with probate. You're going to pay a probate attorney like myself, and you're going to pay well for that. You're going to pay court fees, which are usually roughly for above $500,000 estate, which is usual in Westchester. The court fee is $1,250 alone. You have to serve all the distributees in the will if they don't sign waivers. So you could run into service issues. And wills can be contested in New York, right? So there is that aspect to a will. When you bring a will to probate in New York, although if it's drafted by an attorney and drafted well, it's probably gonna hold up at the end. So people are allowed to contest wills. So there is that negative to a will as well. Yeah. So again, it depends on your familial relationships with everybody in your family. Is everybody getting along? How do people act in your family? And what's their history? Are they litigious? Are they not? Is this an equal will or is this an unequal will? If you're going to do some really unequal distributions, we should probably start talking about a trust to avoid a contest. And you know, that's a personal conversation. Yeah.
Okay, thank you.
Yeah.
Can I just give you an experience I had recently, because my husband passed away this year, and
Sorry. Yeah.
he had several different IRAs from different jobs, and everything was placed. We did a trust for my children are in their 20s, and we did do a trust. And the one thing when I was transferring everything over, because I was the sole beneficiary as his spouse, there was one account that he used to, I think, play the stock market with, and it was very little. It was like $5,000. And it was the only thing that would have had to have gone to probate the way my estate lawyer put our estate together. And when I talked to my lawyer, she was like, don't do it, because it's a wash. What it would cost to go to probate to get that money, everything else transferred because I was a direct beneficiary. But
So,
that one thing.
I'm not going to step on your attorney's shoes here, right? But in New York, when the assets are under $50,000, there's something called a voluntary administration, which is set up for pro se individuals, which means people without an attorney who are doing it themselves. And the filing fee is $1, right? And you can go get a single asset, just like that situation, say it's worth $5,000, and you can do it yourself. So if that asset still exists, I would recommend I can give you the form. You can do it yourself and go get that $5,000. I'm sure even with your hourly rate, it's going to be worth it. Yeah.
I'm calling you, Anthony.
I want to understand the probate. Sorry about that. The concept of it. So if I make a will, it's automatically will go to probate because probate is trying to prove the will is valid. Is that correct? Is it all wills go to probate?
Yeah. So all wills all wills eventually, unless you do a new will that overrides the previous one, right? And I'm sorry to give such lawyerly responses, but will go to the court if there are assets to probate. And they go through this act of probating the will, which means that all the distributees means all, usually it just means children or necessary parties who need to be cited, get cited. They get an opportunity to come and object. And then eventually the surrogate, who's now Saul, will usually issue the letters if there's no contest. Yeah, so all wills do get probated. Yeah.
Okay.
Whereas, and what the tricky thing about a will being probated, I could go in there and go to the probate court and say, I want to see the will of Elizabeth Hobson. And it's a public document. Anybody can see where you left all your money to.
Yeah.
If it's a trust, it's protected, right? Right, Anthony?
That's correct. That's correct. I mean, there are a handful of attorneys in New York, myself included, who can challenge a trust and know how to do it. But it's not what your average attorney is going to be able to do. Like, so in New York, the statute is very clear on how to challenge a trust. There's, you know, it's been done 100 times. Almost none of them go to trial. But to challenge a trust, I'm talking about wills there, sorry. But to challenge a trust is a much more sophisticated thing. And it costs a really good deal of money. So you've got a money bar. You're going to have to go pay an attorney a lot of money to go try to challenge a trust. Yeah. Anybody else have any questions? These are great questions, by the way.
This is Jihye again. I was wondering if you have seen, certain examples of advanced planning that you've seen that's more popular in this environment.
So in the COVID environment, are you speaking of, or?
Just generally this year, maybe a COVID environment, maybe. And there may not be an answer. I was just wondering if you.
Yeah, that's a real, so
had seen.
I don't want to dismiss your question as being general, but it's a little general, right?
It is
So,
general, okay.
I've done some really advanced, really thick trusts this year for, say, a child with special needs, or I've also done one for a very wealthy person who has a child, an adult child, who probably is not great with money and needs to be severely restricted. And this is, we went into the weeds on this one. You know, she really wanted to make sure that he wasn't going to spend away a good deal of money, a really good deal of money. But everyone's issues are very specific, right? So your issues are not going to be my issues, and all of us are going to have a separate issue. And every time I answer the phone and someone says, Anthony, the first two questions I always get are, how much does the will cost? And mine is really straightforward, so I know it's not going to be complicated, right? Everyone says that. And then you come in, and then we talk, and they're like, oh, well, I guess there's one or two things, right? So everyone's just so specific and individual. I can't really answer that one. Yeah.
Anthony, how often do you think people should review their healthcare proxy and their living will? Do you think that needs to be updated every 5 years?
I mean, 5 years is aggressive, right? I mean, if you're a type of person who can do that, that's fantastic. And by updating it, it would just really be like looking at it for 1 minute, making sure these people are still alive, and making sure you still like these people, right? And if that's the case, you can just put it back in the folder and put it back in the drawer for another 5 years. That would be great.
Do you often have what happens if the executor dies?
I usually put substitute executors in my documents. And I've had I've probated other attorneys' work, right? Where, there's a lot of attorneys out there who are not estate planners who will just draft wills, right? You're not planning for your estate, you're just getting a will done, which is fine. And sometimes they don't put successor executors. And then there is a procedure under the EPTL, the Estate Powers and Trust Law, where we can get anybody actually to come in as a fiduciary, as long as the beneficiaries the distributees are okay with it. Like, and very often, to be honest, I'll step into the role a lot in those times. because people would be like, I don't want to do it. And they might know about how terrible it is to be a
It's
fiduciary.
such fun.
And I just
I
go,
got 25 pounds of fun, let me tell you.
I go through my robotic motions, go down my checklist, get everything done, scream at banks, get the monies, marshal them, account for the monies, distribute the monies. The process usually takes about 1.5 years. It's not a fun process. Yeah.
One question, Anthony. Regarding the probate, you say all the wills will be probated. I understand that. So, assuming every asset in the will is non-probatable, like for instance, life insurance or whatever,
Yeah.
does that will still has to be probated?
No.
The second question is, if I put a trust, like you mentioned, put the trust in my will, that still needs to be probated, right? Even if I put the trust doesn't protect you from being probated. So is that right?
Okay. So if you have no probatable assets, we will not probate the will because there's no reason to, right? If you have a minor trust or a trust within your will and it's being funded from an outside source, we do have to probate that will in order to get letters of trusteeship to validate the trust within your will. There are two types of letters testamentary or letters of trusteeship, which would come into effect there. And you would have to get both. Yeah.
So in my will, I designate executor. I designate a guardian for my kids, and I designate a trustee for that trust.
Yes.
But they still need to go through probate.
Yes.
Right? Okay.
If you have probatable assets, right? Again.
Got it. So the main assumption is if you have probatable assets, even if you have a trust, have executor or guardian and trustee, you still go through probate then. Okay. Right?
Yes. In the same scenario we're in, the answer is yes.
Okay.
Yeah. All right.
Could I share one other thing that ran across my desk in the last 8 months that I've worked with a couple of different people who've told me that they've had to reevaluate what their living will said and their healthcare proxy because of using the term intubate. Because the need for intubation with COVID, many people had said, I don't want to be put on a ventilator. I do not want to be intubated. And it's something that people now are looking at a little bit differently. So if anybody does have that in their will, in their documents, they may want to revisit that particular section. Because prior to COVID, we weren't thinking of intubation and life support in that terminology. So I just wanted to share that with you guys.
Yeah, that's a really good point. But remember, to get to that point, it's so like I know that my living will, you have to cross a couple of thresholds in order to even get to what you want or not, right? And that would include a terminal condition, a permanently unconscious condition, or a minimally unconscious condition, which you are permanently unable to make decisions, right? One of those would need to be hit. And I don't think that COVID would fall under any of those three categories. And I don't think that the intubation would be restricted because you don't fall under one of these prerequisites to have the living will come into effect. But it's still a really good point. I'm going to really revisit my living wills and think about that. Yeah.
Yeah. Anybody else have a question, comment? Because we're now coming up on an hour already, if you can believe it, Anthony.
Oh, wow. Okay.
What a team.
So I don't have a question, but I just wanted to share that while I was listening, I pulled out my lockbox and I looked at my power of attorney and my healthcare proxy, and I realized that my husband's wasn't signed. So this has been really helpful.
That your what?
My husband's was not signed. It wasn't notarized.
Oh.
So I gotta fix that.
Yeah. Yeah, you do.
Yeah, no, it's always good to look at your documents from time to time. Before we go, I just would like to just go back to our beginning picture that we had of Mary. Anthony, could you maybe just take us to the last screen?
Yeah, sure.
In the beginning, when I was telling you about my dear friend Mary that passed away, can you share the screen, Anthony?
The first one?
Yeah, the last slide, while I finish wrapping up the story about Mary.
Sure, I'm going to share it right now. Give me one moment.
The interesting thing about Mary is Mary and I had met at the train station in Dobbs Ferry. She used to sell coffee down there with her first husband. And we would take the train into Manhattan, and we became train buddies. And I said to her, hey, do you know how to crochet or knit, or how about quilting? Do you like quilting? And she said, yeah, I'd like to learn about quilting. I said, well, we're doing a quilt at the library, and if you would like to, Anthony, can you pick up that logo in the upper corner? It's just a little it's slipped down. I don't know why.
Okay, I'll see what I can do.
Okay, thanks. So what had happened is Mary started doing the quilt with me at the library, and then she became actively involved with the Friends and served on the board. And when I was the treasurer and Mary was the president, we set up an endowment for the library because we had already saved up about $100,000. And I was going off the board, and I said, I really don't want to see new people come in and spend that money down. And it was a little bit unpopular with some of the people in the community at the time, but I really wanted to think about having something in the future to be able to help the library in perpetuity. So we sat together, Mary, Carmela, I think Pam Bernstein was on at the time, and we created this endowed fund. And what happened when Mary died, she left half of her estate to the library, and she had said, I wanted to go to that thing that we built. And I was like, what thing are you talking about, Mary? She goes, you know, that fun thing. And I said, oh, the endowment. She said, yes, I want the money to build our endowment. So Mary was committed to the library so much, and I'm fortunate that she was my friend and that she thought enough of the library and our community to want to leave something and create a legacy here at the library. And we already had one woman in the community say, I want to start a knitting group. So we've got a bunch of people knitting scarves now, and it's called Mary's Yarns, and it's a great little program. And we love to be able to recognize Mary by continuing to do these type of things. So we have on our website the language that's in front of you right now, because in case you are interested in leaving bequests to the library, there's certain words that you have to use. And if you wanted to talk about, say, donating money for children's programming, you know, we can certainly talk about that. And I'm very happy to use my other professional skills to help you figure out how you'd like to be able to make a gift to benefit the library in perpetuity. So if you have any other questions, always shoot an email to the Dobbs Ferry Friends of the Dobbs Ferry Library, call the library, tell them you'd like to speak to somebody, and we'll get back to you as soon as possible. Thank you, Anthony.
Yeah, thanks for having me tonight. It was fun.
Thank you.
Okay, bye, everybody.
Very
Thanks, Anthony.
informative. Thank you.
Bye.
Nice to meet everybody, too.
Good night.
Thanks, guys.